The city of Huntsville and police officer William Darby, who last month was convicted of murder, will head to federal court soon to argue that the lawsuit against them should be kept on hold for now. Attorneys for the estate of Jeff Parker, the man Darby shot and killed 3 years ago, are asking a federal judge to let their excessive force and wrongful death lawsuit against the city and officer move forward. The attorneys argue that a stay in the lawsuit should be lifted now that Darby has been convicted of murder. Lawyers for Darby and the city want to keep the suit on pause until after Darby's sentencing in August. U.S. District Judge Liles C. Burke has scheduled a hearing to address the debate on June 21 at the federal courthouse in downtown Huntsville. "We're a month from the verdict and we're ready to move forward," said Martin Weinberg, one of the lawyers for Parker's estate, in an interview with AL.com. "Our motion speaks for itself." Judge Burke issued the stay shortly after the lawsuit was filed last year. Attorneys for the Parker estate at that time did not oppose the delay, which was meant to protect Darby's Fifth Amendment rights against self-incrimination, as his testimony could have been used against him in the criminal case. With the criminal trial over, attorneys for Parker's estate now argue that Darby gave up his right to remain silent when he took the stand in his own defense during the murder trial. Therefore, this case has been unnecessarily stayed for over a year, the attorneys wrote in their motion filed last week. Greg Burgess, an attorney representing Darby in the lawsuit, wrote in a response that lifting the stay before the sentencing would be premature. He argued the criminal case won't reach its final disposition until the sentencing. Officer Darby is participating in the ongoing pre-sentence investigation and upcoming sentencing hearing, Burgess wrote in court records on Wednesday. As such, Officer Darby's private interests still weigh in favor of a stay due to the significant time commitment required for this process, including critical preparation work with his criminal defense attorney prior to his sentencing hearing. Plaintiff totally overlooks this reality in seeking a premature lift of the stay. Alan Anderson, an attorney representing the city, also on Wednesday filed a response supporting Darby's stance that the stay should remain in effect. The similarity of issues in the underlying civil and criminal actions, the status of the criminal case, and the interests of plaintiff, both defendants, the court, and the public all weigh strongly in favor of a stay of these civil proceedings during the pendency of the related criminal matter, Anderson wrote. Attorneys for the city and Darby also cited a gag order issued by Madison County Circuit Judge Donna Pate, prohibiting parties in the criminal case, Darby, attorneys and law enforcement, from making public comments about the case.